Judge, good morning. These are my motions for default judgment in order of reference with respect to multiple parcels. Judge, I don't believe there's any opposition as to my motions. Judge will note to the court that there is one parcel, map 67, parcel 71.00. I have stricken through that to continue it by agreement. Mr. Andrew Mills is in the process of getting a partition suit filed and served. So I've agreed to continue that one. He's going to get the taxes paid through the partitions.
As to the other defendants, is there anyone here to contest the motion for default by the Dickson County? And your motion for default in all other regards is granted.
Thank you, Judge. There is also a motion for excess funds to be distributed to the city of Dickson, which Mr. Smith has filed. I have reviewed his motion. It is well drafted, in my opinion, well taken. I don't have any opposition.
So he's told you that you did a good job of drafting this motion, and so I'm assuming that maybe paying you that compliment means that go easy on the taxpayers. I don't know exactly. So, what do you have to say, Mr. Smith? This
Good morning,
is your
Honor. The city of Dickson recorded 4 liens against property at 515 North Main Street. Mr. Osborne did prosecute a delinquent tax sale on behalf of the county. Excuse me, the city's taxes, there was a separate tax lien that were, I believe, paid already. These are liens for vegetation and demolition on the property. I have the codes director, Jason Pilkington, here. I attached copies of those liens to the motion. If you'd like to hear proof, they're available.
Is there any opposition to it? No opposition to it, then I don't see any need to put on proof because I think you would be entitled to your motion.
Your Honor, we're seeking a total of, I believe, $15,368.25 for those liens, and I do have an order prepared.
All right.
Also filed a motion requesting that any remaining funds in the estate account held with U.S. Bank be paid into the court. We'd previously sold some property in this estate that has been paid into the court in an interest-bearing account. And as we're moving towards, of course, the distribution, I think it only logical to have all monies paid into the court. Really, the remaining things that we'll have to do, Your Honor, on this estate is going to be to verify on what taxes will be due. I think at that point, then we can move towards the distribution. So we would have just a little time. So I'm asking the court to grant that motion as well, to have the remaining funds in the U.S. Bank account paid into the court, into that interest-bearing account.
Ms. Franklin, any objection?
I have no objection at all, and I've reviewed the accounting.
And Your Honor, the accounting and all was sent out to everyone, all the heirs at law, all the attorneys involved, December the 3rd. I have not received any objections, and to my knowledge, the court has not received any objections.
All right, there's been no objections filed, so I will grant your motion.
And Your Honor, on the accounting, I know that there's a place for the judge to sign up. I'm sending up an order for Your Honor to sign as to that motion as well. And Your Honor, Ms. Coffenberry is part of this case. I don't know if she has any statements to make.
Do you have anything you want to say, Ms. Coffenberry?
No, Your Honor, we've all reviewed everything. We just want to get to the place where we can conclude this estate, so.
All right, then I have signed the order. Thank you.
Thank you, Your Honor. Your Honor, may I approach the court?
All right, this is an exception to the claim of Horizon Medical Center. Anyone here for Horizon Medical Center to prosecute the claim? No one here to prosecute the claim. Your exception will be granted.
Thank you, Judge.
Good morning. If you'll raise your right hand, let's place you
Morning,
under
Your
oath.
Honor. I do.
You are Carolyn Henderson, is that correct?
Yes, sir.
Hendrickson, I'm sorry. Ms. Hendrickson, you have filed a complaint for divorce using a form the state provides online for individuals wishing to represent themselves. That purports to bear your signature and that contains certain information. Is that information true and correct?
Yes, sir.
You've also filed a marital dissolution agreement. Is that your signature on that agreement?
Yes, sir.
And is that your husband's signature?
Yes, sir.
The form that the state provides is very confusing on the second page, especially where on number 6, it has a situation where it says neither spouse is pregnant, and you either have to check yes or no. And you've checked both of them because then I can understand because it's very confusing. But number 7, or below that, it says if you check no on any box, you cannot use any of these forms. Do I understand correctly that you mean that your intent was to say that neither spouse is pregnant in your situation?
Yes,
is that
sir.
correct? So the checking yes in agreement with that statement is why I think it's poorly drawn, but anyway. All right. Then with your permission, I'm going to mark out the no box so that it will be correct. And
Yes, sir.
I'll initial that. Have you prepared a final, do you believe that that marital dissolution agreement fairly and equitably divides all your property and distributes all your debts?
Yes, sir, we had
Is
no
there anything
property.
between you and him that's not addressed?
No,
And have you prepared a final decree of divorce?
I'm not sure what that is.
Well, there's a form that you have to go back to that same website, and that website will provide a form called a final decree of divorce. That's the actual document that grants you the divorce. And you have to fill that out completely and send a copy of it to your husband at his last known address, and then bring that into the clerk's office. You don't have to reappear in court, but if you will get that form, fill it out, get it to the clerk's office, then I'll sign off on it, and your divorce will be granted, but it will be granted officially when that order is signed and filed, okay?
Yes, sir.
All right, so you're going to get us a final decree of divorce, correct? Because you're not
Yes.
divorced until that's signed.
Yes.
All right, good morning, both of you raise your right hand. You folks were here the other day, weren't you?
Yes, sir.
Let me just, I'm going to go through the same routine that we did before, but you are Andrea Lynn Cromwell, is that correct? Ms. Cromwell, you filed a complaint for divorce that using a form the state provides online, and that contains certain statistical information. Is all of that information true and correct? You and Mr. Cromwell have now completed an amended marital dissolution agreement that I have reviewed, and it is notarized. Your signatures are notarized on that, and that purports to distribute all your property and deal with all your debts. And do you believe that that fairly and equitably divides everything?
Yes, sir.
Mr. Cromwell, is that your signature on that document?
Yes, sir.
And do you believe it also that it completely and fairly distributes all your debts?
Yes, sir.
And all of your property? And there's a provision in there for this real property, and it makes a provision that one of you is going to receive that, and I don't remember which one, but one of you is going to receive the property. But you're going to, as I explained to you, you're going to need to get a quitclaim deed prepared by a lawyer to have that transferred, her interest in it transferred over to you, so that you don't run into a problem in the future in case you want to ever sell it or transfer it, because there'll be they'll do a research and they'll come up that there's a problem because there was no transfer of her interest by marriage. All right, then I will grant your decree. Do you have a final decree?
Yes, sir.
And Ms. Cromwell, we're changing your name to Andrea Lynn Smith, correct?
Yes, sir.
All right, both of you signed off on the last page, so you've done everything correctly. I'll sign your final decree and grant your divorce. You can get a copy of it in just a little bit from the clerk's office, and you will need to do whatever you need to do with this copy, okay?
Yes, Your Honor. My name is Greg Cashin. I represent Sumner Glass, the plaintiff in this case. And one word we don't use with this case is recent. This case has been going on for like 7 years. And
This involves the Dairy Queen.
Dairy
correct?
Queen, yes, sir. And what happened here was, if you notice in this file, there's a slew of other parties. And what happened was the general contractor went broke, and my man was the glass and glazing. And as you can see at the Dairy Queen now, all that's been put in and used for 7 years. And we were just trying to get in front of you because he's been paid zero. So his bill for this was his estimate, what they gave him, what everybody agreed he was owed was $19,500 or so. And he's never received a dime. And on the other side, what's going on there is the owner, of course, was more of a victim of a bad general contractor, best I can tell. I don't want to cast aspersions, but that's where he paid $10,000 to the general contractor for the glass. General contractor never paid my man. So here we are, he's upset because he has to pay twice now to get the $19,000. And the reason this has been slow in coming is we weren't sure what was going to happen in the bigger case, but at the same time, the owner has alleged that we did defective work, and that's an issue of fact. And so that's the allegation that is problematic with this case, you giving me summary judgment, because there's an allegation of issue of fact, which will kill it most of the time. And what we're really asking the court to do is to look at that, and if it's something that you could realize how long they've had. They haven't given us Mark Ogle has photographs, but number one, the photographs, they've never given us an invoice. Plus, I think the real reason is because when we did the glass, we put all the glass in, we put it in the dead of winter, glass is going to shift a little bit. And he would normally come back and work off the warranties for the work. But because the owner never paid him, he never called him back. So here you have another scenario of events where he never received a call to come back, and you get into the doctrine of notice an opportunity to cure, if that's going to be the defense here. But for today's hearing, I don't think if there's a hint of a fact that I can get you to go summary judgment, because Court of Appeals reverse everybody every day if they can find. I had stipulations, both parties had stipulations, and Judge Bennett still found an issue of fact. I'm not real
Well, if
optimistic.
it makes you feel any better, when I first took the bench and we had a judge school, one of the older judges made a comment to all of us who were brand new and said, if you don't want to be reversed, don't ever grant a motion for summary judgment. And that's been my experience, but I have granted a few from time to time, but most of the time there is some sort of an issue and the Court of Appeals will reverse if, in fact, it's a process that can work if there are clearly absolutely no issues. And the times that I've been affirmed when I've granted it was because it was such a very clear lack of any material disputed fact that even the Court of Appeals agreed it should have been granted. But it's basically cutting off anybody's opportunity to have a hearing on the merits, and that's why it's not really favored. But in any event, I appreciate your honesty about the fact that it's rarely ever granted, but
Right.
I know you're here today to argue that there's a partial summary judgment should be granted, so.
Well, I guess we're both on the same page, because I wanted to know who all these other people were, and none of them show up, and none of them's done anything. And I'm guilty. I haven't pushed this as hard as I could, but I knew I had the issue of fact. And I've talked to Mark, and I think the best resolution, given where we are today, is first to bifurcate my little case, my $19,000 case, out of this other group of people that aren't doing anything. They're not doing discovery, they're not doing anything. 'Cause I thought they could do discovery and prove that we didn't have any defective work, but that they're not doing anything. So I would like the court, and I'll let Mark, I think we agree on this, bifurcate this case and give us the earliest date possible, because we'll have a half-day trial. I've only got one witness, and he's not going to be long. So that's what I see, because I don't want, that issue of fact always kills this. And I want to get.
So instead of actually arguing for a partial summary judgment, what you would prefer to do would be to sever your clients. You refer to it as bifurcated, but basically it is, there was a consolidation order, if I recall correctly, that joined all of these claims.
Right.
And you're wanting to sever your client's claim and have a hearing on his claim outside of all of the others.
Correct.
Okay.
That's what I'd like for the court to do, so we can.
Well, let me hear
Do it
from
right.
Mr. Odle and see what his position is about that.
Thank you, Your Honor.
Yeah, apparently we're not going to really consider the motion for partial summary judgment. We're just talking about, this thing's been going on for a number of years, and I don't blame Mr. Cashin for wanting to try to move it along. And when they're all consolidated, that made sense at the inception of it. But now it's been pending for so long, you've got someone who did the work but has never been paid. So what I'm inclined to do is to grant that motion to sever his client's claims and set a hearing date according to whatever everyone's calendar can permit. You're referring to the person who was actually the general contractor on the construction. So let me ask this question, without me having to go through this voluminous file. In this particular situation, what I'm dealing with today is Sumner Glass LLC versus Justin Caleb Story individually and the JCS Properties LLC. And it's a claim for the monies, the $19,000 or so that Sumner Glass says that they should have been paid but weren't. Your response is, if I'm understanding, that your defendant, Mr. Story, paid the general contractor, whether he was licensed or unlicensed, he paid him for the glass, and that glass has never been transmitted over to Sumner Glass. So the question becomes, excuse me for cutting you off, but I didn't finish what I was getting at. So have you filed a cross action against Mr. whoever the general contractor is for the monies that your client paid that should have been paid? So who represents that general contractor? Would it not be appropriate then, if we have a hearing on Sumner Glass's claims against your client, that your cross action against the general contractor also be included in that? We're not limited. I'm just basically trying to figure out, if I have a hearing and it's only about Sumner Glass versus your client, and your client says, I pay the contractor, well, then how does that solve Sumner Glass's problem? It doesn't. I give them a judgment against you, you say your client's already paid, then your claim would be for reimbursement from that person. And if he's not included in that, I see problems. So while we can sever this case, this claim, I think that your cross action against him for that portion, he needs to be given an opportunity to participate so that there's no issues raised that he wasn't given an opportunity to participate in the case. So I'm of the opinion that an order needs to go down to sever this claim, and your cross action against the general contractor for limiting that to the issue of whether or not he was paid for the glass work, and whether he did or did not pay for it, and is your client entitled to reimbursement for any monies that this claim produces, and then we'll set it for a hearing. Now, I think Mr. Carr, if he represents the general contractor, may have some objection to that, but I'm of the opinion that we'll give him an opportunity to be heard on that. But right now, that seems to me to be the most logical way to proceed. Now, the question is, when do you want to have this hearing? According to Mr. Cashin, it wouldn't be a really lengthy hearing because of the fact that he's just got one witness to testify what he did. You may have some more witnesses about any defects that you're claiming as an offset, but we'll probably be looking at least a half a day to a full day, I would think. So the question becomes, how quickly do you want to try to do it? Well, you'll have to schedule it through me and my assistant. So what I would suggest we do is let you and Mr. Cashin talk, and somebody needs to contact Mr. Carr, tell him what we're doing, and that I would like to know what dates you're looking at, and then how quickly you're looking, and then we'll go from there. So, all right, that'll work. Then let's have somebody draw an order to this effect. Is that microphone on?
Now it is.
I just thought you had such a soft voice. You represent the Stamper?
Ms. Stamper, Rachel Stamper, and Mr. Atchison represents Mr. Stamper. But, Your Honor, this was set for motion for temporary parenting plan. Mr. Atchison and I have reached an agreement as of yesterday, I think, and my office is preparing a temporary parenting plan, and we'll be submitting it. Just out in abundance of caution, I would ask that all motions, including Mr. Atchison's, I think, be passed and reset to the 27th in the event that there's some glitch and a problem arises.
All right, then we'll move everything to the 27th, but you're telling me you're preparing an agreed order to resolve the matter.
It's being prepared right now at my office.
That's it.
Thank you, Judge.
Thank you, Judge.